Let's bring in our guest. Joining us now to discuss, National Trial Attorney Michael Jaafar. Michael, great to see you. Thank you so much for joining me here on the program. And, you know, it's a bit of a sideshow here. This is sometimes the way the criminal justice system works. She had concerns previously that, again, as I mentioned, he wasn't competent. You heard his attorneys making the argument that he's had some issues. You know, he had a very bad motorcycle accident, made all the newspapers back in the day. I think it was the late 80s. He was in a coma for a while, still struggling with some mental health issues, but he was found to be competent. What do you make of what we're watching right now?
I like the way you framed it, a sideshow, because from my days as a public defender, pretty much every day was a sideshow. And so this is not unfamiliar to me, his behavior. Believe me, these judges have seen many worse. This judge particular sees misdemeanors, which means she sees all kinds of character come through her courtroom. She's handling it well. She's handling it with grace. If that judge did not believe that he was having competency issues, she would have reacted much differently. She would have put him in contempt. She would have asked him to surrender himself to authorities. But I think that this judge believes that he doesn't know what's happening and that he has these competency issues. So I believe that it's a sideshow, like you said. We'll see what happens.
Yeah, and again, he's much better this time, Mike, than he was the last time. Last time, he clearly didn't understand what was going on. Couldn't hear. He had a number of issues. At least now it looks like he kind of understands what's happening, able to answer questions. Last time, that was a struggle as well. I want to talk a little bit about the arguments being made by his attorney. He's trying to keep him off probation. For whatever reason, doesn't want him to have any sort of control by the system. It's understandable, right? He's 81 years old. He talked about his mental health issues. Talked about this happened in 2022. He's been good since then. Talked about and no real significant contact with the system since about it, from what I could make out from his record, since about 2011 or so. He had some sort of domestic violence issue. Actually, it was a sexual assault, or at least a claim of a sexual assault for an employee on The Apprentice. That show that was a big hit back in the day. What do you make of their argument, trying to keep him off probation? What do you think the judge might be looking at in making this decision?
The judge is going to have to put him on probation, but the defense attorney had to make the argument for him not to be on probation, because as a defense attorney, you always know your customer. He knows that this defendant is going to fail on probation. That video of that gentleman who attacked the judge in Las Vegas, that was a show cause hearing because he had violated his probation. Defense attorneys know which client is going to violate probation. So this defense attorney is working hard to keep him out of it, because if he's not, he's going to be show cause every other month to come in front of this judge and appear why your client did not follow the probation.
That's interesting. So he's actually making the argument, Mike, that because he's 81, because he's got these physical and mental health issues, because he's not going to be putting himself in the position he was when he committed this particular offense. He's not going to go out and do these sort of shows or whatever they do when they go out and make a few bucks, that he's not at risk for reoffending, right? That's really the argument he's making. But you're claiming he knows that there's a likelihood he would reoffend, and he'd be dealing with this on a constant basis.
If he and I were having a beer, we would tell each other the same thing, me and this defense attorney. 1,000% he's going to violate the probation every other month. And that's why he's doing it. He can't say that to the judge. But between you and I, that's why he's fighting so hard.
Fair enough. I mean, you know, he could be going out to the grocery store and find himself in a situation where he's doing some sort of, you know, sexual contact. So it is a serious concern. I mean, we're making light of it, but it's a serious concern. Yeah. All right. I want to take a break here, Mike. Stand by. All right. So the judge making sure to get on the record that she got documentation that he is, in fact, competent. I mean, he seems competent today. 2 years probation for Gary Busey, $50 fine, no contact order with the victim in the case. Let's bring back in National Trial Attorney Michael Jaafar to discuss. Mike, first I want to get your reaction. The judge did what judges have to do under these circumstances. They weighed aggravating, mitigating. She decided ultimately probation was appropriate under the circumstances. And I thought the one that stuck out for me is she made clear that there was a need for deterrence.
100%, because what would have happened if she didn't give him any probation? He didn't even appear in court. He was in Malibu, California, not appearing in court, cutting her off, went to the bathroom. This judge's reputation would have been in the toilet if she didn't do it. I think she did the right thing.
So listen, she gives him probation. He didn't have to appear. He was able to do it via Zoom, etc. So what does probation look like for him? Is he going to be able to do that via Zoom, or he's got to appear? Because you heard her say, and it goes back to what you talked about earlier, Mike. She said, look, if you fail to show up or don't treat this probation thing seriously, you could end up doing 18 months in prison.
Yeah. There's reporting probation, non-reporting probation. To answer your question, probation is whatever the judge's imagination is. I've seen some judges say probation means you have to go on the courthouse steps and make a speech to youths who look up to you, not to do this, not to do that. I don't want to mention names, but this happens all the time. Whatever the judge's imagination thinks they can do to benefit society, they will put in their probation, and I think he's going to fail.
Now, Mike, I might agree with you on that, but Mike, you mentioned earlier this idea that, he did in fact take this plea. What do you think about the decision to take the plea in the first place? He was charged with something a little more serious. There were 3 different charges, 3 different women. They got it knocked down to the 1 and the misdemeanor, which I think is a fairly good deal. But what are your thoughts?
I think this is why certain states allow something called a no contest plea. I did some research. You can't do it in New Jersey. In other states, this is ripe for a no contest plea because by pleading guilty, essentially, he has no defense to the civil case that's going to come. The civil case is going to be way more difficult than the criminal case. Had he been in a state where he could have taken a no contest plea, he would have gotten a no contest plea. Just the fact that he couldn't even get through the elocution and the sentencing, he couldn't even get through it. Right? A no contest plea would have taken that all out of his hands, and he could have defended himself in the civil case. Couldn't do it in New Jersey. Kind of sucks for him. His defense attorney, their hands were tied. I think they did the right thing.
Yeah, at the end of the day, you did mention the civil case. He is being sued by the victims in civil court as well, so he'll have to deal with that. And I want to talk quickly about the purpose of probation. You look at someone like this, 81 years old, mental health issues, and we talk about the fact that it's possible he could reoffend. But what is the purpose of probation in your mind? I think of it as some sort of punishment, right? You want to set an example. The deterrence is absolutely an issue as well. And also, there's this element of protecting society that I think goes along with it as well.
It's what you just said. This is the proverbial slap on the hand. That's what probation is. It's a slap on the hand. And a lot of times probation is really for people who are drug offenders because in probation, you could make them do their blood alcohol. If they're addicted to alcohol, addicted to drugs, you could say, test for no alcohol, no marijuana, no substances. That's really the purpose of probation, is to really help somebody recover from the crime that caught them, brought them into your courtroom, as well as deterrence and protecting the public. So all of the above.
Yeah, and at the end of the day, I'm so glad to hear that there was a victim impact statement. The judge mentioned that she read that victim impact statement onto the record because, again, although it's a misdemeanor, criminal sexual contact, it's a very serious offense and can really be abusive to the person who had to experience that type of thing. All right, Michael Jaafar, thank you so much for joining me this afternoon. Truly appreciate it, my friend. We'll see you again real soon.